Welcome to this explainer. I am absolutely thrilled to have you here today. Okay, let's just dive right into this, because today we're untangling an invisible legal minefield that is hiding right behind our modern innovations. You might think creating a successful product is all about brilliant engineering and, well, finding your market. But there is a massive, completely hidden layer of legal complexities dictating who gets to innovate and who gets shut down entirely.
250,000. Just let that sink in for a second. That is the estimated number of active, overlapping patents currently protecting a single modern smartphone. That device sitting in your pocket right now, it isn't just a miracle of technology, it's a tangled web of 250,000 individual legal claims.
Section 1. The 250,000 patent phone.
That staggering figure really proves that launching a new, complex device in today's market isn't just about crossing a competitive moat to beat out your rivals. It's about navigating a deeply dangerous legal web. Think about it. Literally every single component in that smartphone, from the specific chemistry of the battery to the shape of the antenna, right down to the specific way your finger swipes horizontally across a screen to unlock it, is covered by intellectual property rights. This means that no single company, not even the absolute tech giants, can build a device without relying on thousands of patents owned by someone else. They require massive, complex cross-licensing agreements just to survive, let alone ship a product.
Moving on to Section 2. Welcome to the thicket.
Economists and legal scholars actually have a very specific name for this terrifying web of intellectual property. They call it a patent thicket. The modern usage of this term was perfectly defined by economist Carl Shapiro back in 2001. He called it, quote, a dense web of overlapping intellectual property rights that a company must hack its way through in order to actually commercialize new technology. You could have the funding, you could have a perfectly viable invention and a ready market, but standing right between you and the customer are thousands of potential infringement claims.
Now, this reality completely shatters the romanticized myth we've all been taught, doesn't it? We all love that idea of the lone genius toiling away in a garage to invent something entirely new. But the reality is that innovation today is a highly simultaneous, highly social phenomenon. Complex tech requires thousands of fragmented incremental patents that overlap. And this reality, it creates a ton of friction.
Overlapping patents aren't exactly a brand new problem. Historically, we saw the sewing machine patent pool back in 1856 and the aircraft patent pool in 1917. Both of those were created because litigation had basically brought production to a complete grinding halt. But jump to the modern era. The scale and the cost today are totally unprecedented. In 2011, Google paid $12.5 billion for Motorola Mobility, primarily just to acquire its 17,000 patents as a defensive shield against competitors. And just a year later, a jury awarded Apple over $1 billion in a patent dispute against Samsung. The thicket has literally become a multi-billion-dollar battlefield.
Section 3. Trolls and royalty stacking. This environment has naturally given rise to entities that specifically exploit these dense modern brambles to extract massive profits. I really want you to consider this provocative question for a moment. What happens when you hold patents, but you don't actually manufacture a product? Think about it. If you have no factory, you have absolutely zero risk of being countersued and having your own factory shut down, right?
Right, and this introduces us to non-practicing entities, or NPEs. You've probably heard them called patent assertion entities, or more colloquially, patent trolls. These organizations acquire patents strictly to extract licensing fees through the threat of litigation. They weaponize the thicket. Because they don't make anything, they can't be cross-sued. They create a massive prisoner's dilemma for actual creators, forcing what's called royalty stocking. This is where the cumulative licensing fees required to avoid lawsuits can literally exceed the profit margin of the actual product itself. It's wild.
And if you try to fight back, well, the numbers are just shocking. The median cost to litigate a U.S. infringement suit with significant value at risk is $5 million. In 2024 alone, total U.S. patent jury damages exceeded $4.19 billion, with 12 individual cases topping the $100 million mark. Treating a patent thicket purely as a legal issue you can just fight in court is an incredibly expensive and often fatal mistake for a company.
Which brings us to Section 4, the pharmaceutical fortress. Now, the tech sector mostly deals with cross-licensing thickets, but in the medical field, patent thickets play by an entirely different set of rules. Take a look at this jaw-dropping number, $114 billion. That is the cumulative U.S. revenue generated by AbbVie over its delay window for the biologic drug Humira.
Humira's core patent actually expired in 2016, but they successfully kept cheaper biosimilar competitors completely out of the US market until 2023. So how on earth did they do that?
They built a fortress, that's how. After 2014, long after the drug was already on the market, they secured 132 additional granted patents covering manufacturing methods, formulations, and dosing regimens. So the crucial point here is that in pharma, thickets aren't used for cross-licensing or bargaining. Pharmaceutical companies already have the patents they need to make the drug. Instead, they file hundreds of continuation patents to build a pure exclusionary fortress. It's all just to delay generic competition and maintain their monopoly.
Section 5. The Patent Death Squads.
Okay, so between billion-dollar tech giants trading portfolios and pharmaceutical fortresses, where does this leave the lone independent inventor? Well, the reality for independent inventors is stark. 84%. The America Invents Act established the Patent Trial and Appeal Board, or the PTAB, as an administrative tribunal to review challenged patents. But their historically high rate of canceling or invalidating claims, which sits right around 84%, actually led former judges to dub them the Patent Death Squad.
For independent creators, this system functions basically like a financial attrition machine. The PTAB uses lower standards of proof than district courts do. Defending an issued patent here can cost up to $1 million, and giant corporations can just file multiple overlapping petitions until they finally win. Take Glenn Sanders and Howard Stark of Zaxcom as a prime example. These guys literally won an Emmy for their digital wireless microphone technology. Yet when massive competitors infringed and petitioned the PTAB, their patents were declared obvious and invalidated 14 years after they were originally issued. The thicket, combined with this system, severely burdens the lone inventor.
Section 6. Hacking through the brambles.
So with all these obstacles, how do innovators actually survive this environment? First, we have to look at the theory. Growth economists propose something called the separation principle. It suggests patent laws should be interpreted strongly against those simply copying or consuming a product, but they should be interpreted weakly against those who are actually using the innovation to innovate further. Adjusting our legal frameworks toward this principle could seriously help maximize social welfare and exponentially increase technological progress, finally breaking the stagnation of the thicket.
But on a practical, day-to-day level, innovators have to make real operational shifts. First, map the patent landscape before you even scope the project. Second, run your freedom to operate searches right at the ideation phase, not right before filing. And third, use defensive publishing to establish prior art on incremental features, preserving your freedom to operate without the heavy cost of a full patent. The vital takeaway here is that discovering a blocking patent before you begin engineering is virtually free. Discovering it at your product launch? Well, that's an absolute disaster.
Which leaves us with a really powerful thought to close on today. Is the modern patent system, with its incredibly dense thicket, million-dollar defense costs, and pure exclusionary fortresses, actually fulfilling its original constitutional duty, to promote progress in the useful arts? Or has it simply evolved into an expensive moat, protecting only the established giants at the expense of true grassroots innovators? It is a truly fascinating and complex landscape. Thank you so much for exploring it with me today, and I really hope this explainer gave you a clear map to help you understand the brambles of the patent thicket.